My lord, I am carving leave of this honorable court
Yes.
to move on CRP. My lord, what is the background of the case is this, my lord. There was an ex parte decree, my lord, against of me. So I have moved an application before the district council, my lord, under Rule 9, under Order 9, Rule 13, my lord. Till now, my lord, the order, what was the order passed, we don't know, my lord. And only in the E-code, my lord, we came to know the matter has been fixed now on 17 September, my lord, for appearance of both the parties in my application. And today is the date of eviction also, my lord. And they have already started throwing the things of my house, my lord, the opposite parties. So I am praying, my lord, if this matter can be taken up and a limited protection may be given to
You
me.
already filed a matter.
Yes, it's already my file.
You're saying that
Yes.
eviction is carried out now.
Eviction, yes, they have gone with those hired, my lord, bouncer, my lord.
They file execution also.
Yes, my lord.
When was the decree passed?
2018, my lord.
2018 decree.
Yes, my lord. No, what happened, my lord? My mother met with an accident.
Where's the property?
Is in Lycor, my lord.
That's very difficult.
Only thing is this, my lord, if I can be given a protection, limited protection till 17, my lord, because my matter will be taken up in district council, my lord. I can fight it out there, my lord.
Why did you move the matter when you filed it?
No, my lord, because I was waiting for the order of the district council. When I filed an application, when I came to know about this ex parte order and all, my
No,
lord.
when you went for when you filed an application under Order 9 Rule 13, you didn't move it immediately.
No, we have moved it, my lord. Till now, my lord, the copy of the order has not been given
Whose
to
code
us.
is this?
Code of Laithama, my lord, Judge District Council. Now, my lord, what is the difficulty, my lord? We don't have the copy of the order also. Only we came to know from the E-code, my lord, that the matter is fixed, my lord, and no status quo order was granted to us, my lord.
Doesn't matter if you succeed, we restore to possession.
No, but the thing is this, my lord, what I'm apprehending, my lord, they will throw me out and they will sell the property, my lord. Once they sell, my lord, a third party.
Difficult, Mr. Day. I mean, like, we don't know. Maybe court pass some order tomorrow, different picture emerges. What are we to do?
No, my lord, because I will be placing all the facts, my lord, and my lord may kindly appreciate the facts. And my lord, only thing is this: now my mother, my lord, and three daughters are there, my lord. My mother is already, she met in an accident, and she is, my lord, somewhat, my lord, not in a balanced way.
No, the decree was what terms? You got a judgment decree now.
Yes, my lord.
Where's the show to copy the judgment decree?
It's just been filed, my lord.
Just show your copy.
No, my lord, it's there, my lord. They're bringing it, my lord. Let it be
your copy. I'll not allow. Let me see first. You don't have your own office copies?
No, they are bringing it, my lord. They are just bringing it. They have filed it, my lord. They are bringing it. They are in the filing section.
Your office copy?
Yes, it is in the filing section. Let it be taken up just after 10 minutes, my lord. I will place it, my lord.
What other matter first?
Item 30.
Sorry, Mr. Islam. I have to go to university. There's a Model United Nations, more than 100 children. They asked me to just address them. So got a bit delayed. Yes.
May it please the Lordship. Lordship, my learned senior has placed 2 points today before this Honorable Court. The first point is paragraph 4 of the affidavit in opposition.
Yes.
If I may take Lordships to paragraph 4 of the affidavit in opposition first.
Yes.
Lord, it says the DSEO is not authorized to pass such approval order, and hence, Lord, this portion is important. Approval accorded by the district school education officer to the resolution by which schools resolves to promote a teacher without BH to the post of assistant headmaster or headmistress is not legally valid.
Yeah.
So in this particular paragraph of the affidavit, there are 2 ingredients, my lord. Firstly, the school has to pass a resolution whereby a non-BEd is being promoted to the post of assistant headmaster or headmistress. And secondly, the approval has to be granted by the DSEO. In the present case, the first criteria is being met, that the school has passed a resolution recommending the petitioner's name to be approved as the assistant headmistress.
Yes.
This particular point has been decided by the Director of School Education and Literacy, who is the competent authority, since the petitioner is not holding a BEd degree.
Yes.
So the Director has decided it in the negative against the petitioner.
Yes.
Now, second point which my learned senior has raised is page number 10 of the affidavit in reply.
Yeah.
By virtue of this page number 10, my lord, what has happened is one of the predecessors of the same school was appointed as assistant headmaster in 2015, despite the fact that he did not have a BA.
Yes.
Now, this particular fact cannot be changed. This has happened in 2015. This document is there on record.
Yes.
But it is a well-settled proposition of law, my lord, that if any irregularity has been committed in the past, it does not mean that the same illegality can be that irregularity can be relied upon to get an order in favor of the petitioner when the same is illegal as of now. Now, this particular order of approval was passed in 2015 manner.
Yes.
But subsequently, in 2023, the notification which has been placed before this honorable court today, my lord,
Yes.
in July 2023, the office has the office of the Director of School Education and Literacy has
Yes.
issued a fresh
Yes.
notification, that is 19 July 2023. That with reference to the subject cited above, I am to inform you that for appointment of assistant teachers, assistant headmaster,
Yes.
or headmaster in deficit secondary schools, only B.Ed candidates will be considered. As
Yes.
such, you are hereby directed to kindly issue a general circular to all the institutions falling under your jurisdiction not to appoint or recommend any candidate without B.Ed degree, failing which no approval will be accorded by the undersigned. Now, my lord, this notification has come up subsequently and it applies to the petitioner.
Yes.
So the petitioner cannot claim
No, only
any
we're
benefit.
not concerned. Only you concerned about Mr. Islam. How do you show that applicable to you? How? That without that, how do you say that not having B.Ed degree also you're eligible?
Yes.
How?
Yes, law is clear, Your
That's
Lordship.
the only thing. You see, law is clear
Yes.
now. What? How do you
I
see
am.
it?
What is
Yes.
the law, Your Lordship? At present in Devosi School, Your Meghalaya, Your Lordship, amended Assam aided high school high school employees rule 65 is applicable.
Yes. Now, how do you say?
Yes. This is the law, Your Lordship. Book is there.
Yes.
Your Lordship. Qualification of assistant headmaster.
Lord, the law being quoted by my learned senior is there at page number 3 of the affidavit in reply.
Okay.
Yes. I have also quoted my affidavit.
Paragraph 4.
Paragraph 4 years.
Yes.
Academic
Yes.
and other qualification on headmistress, headmistress.
Yes.
This one, and second page, Your Lordship, assistant headmistress and headmistress. Page 4,
Yes.
paragraph 5, Your Lordship. Is a candidate should hold at least 5 years experience in teaching, which may be relaxed up to 3 years in exceptional cases of academic career.
Yes.
Only experience, Your Lordship, 5 years. And this law is holding, Your Lordship. Subsequent any instruction or notification without amending the law, Your Lordship, law that cannot supersede the law, Your Lordship, any notification. And moreover, very interesting, Your Lordship, that 2023, that notification director had passed.
Yes.
Your Lordship, I have also annexed that document, Your Lordship. On the basis, after my representation, here I am indicating, Your Lordship, my representation, kindly peruse, page 29 of my petition,
Petition.
petition. Then they have page 29, Your Lordship, got it. And notice the date, 10 July 2023.
Yes.
I have submitted representation before the director. I also meet, petition also meet the director. Next page, Your Lordship, page 30,
Yes.
second middle portion, the second paragraph, that at the time of my joining in the school, B.Ed degree was not required, and during my service period, I have seen the predecessors, namely late Sansan Sofikul Haq, served in the Receivable Girls High School as assistant headmasters without having B.Ed degree.
Yes.
Furthermore, it also have come to my knowledge from relevant sources that present headmaster of Mohandirgarh Secondary School is the headmaster in the district South West Garo Hills, Meghalaya, namely Devdewal Das, and present headmaster of Jawaharlal Nehru High School, Higher Secondary School, Fulbari, in the district West Garo Hills, Meghalaya, have promoted recently without having B.Ed degree. These are the numbers. So there are numbers of examined students in Meghalaya regarding promotion to the post of assistant headmaster without B.Ed degree. And after that, Your Lordship, they have that Your Lordship resolution, that notification, page 32 of my petition. I have annexed that to it. After my application, had indicated that this is the going, then they have their known. Director has passed this notification issued.
Lordship, this notification
Is
is not the same
21st
what-
July, 21st July 2023.
Yeah, but one thing, MS Agarwal, now the rules applicable are 65 rules, correct?
65
No, my lord.
No.
rule.
No,
What the
my
rules
lord.
now? This is the 2012 rules.
No, no. The
My lord, the
12th rule is
2012 rules are the government
No.
rules, and those rules have brought into force the NCT norms.
No.
And the notification which I have placed before this honorable court today, that is prevailing. The 1965 rules do not prevail. The notification
Without
which has
any-
been issued in 2007 and thereafter reiterated in 2023, they are prevailing at present.
No,
And
the
my
thing
lord,
is that, see, this executive instructions, memorandums cannot override
Override
the rules. Okay, that's what he's arguing.
Yes.
That's the only thing. He says that as per 65 rules which deficit schools are governed under, that means the requirement for appointment as assistant headmaster, you don't need B.Ed. Okay, you only need 5 years teaching experience, correct? In the lower grade.
Lordship, if I may humbly submit before this honorable court,
Yes.
my learned senior, with all due respect, has come up with different submissions on different occasions.
Alright.
One day he argues that the 1965 rules apply to him.
Yes, I have
The
also
second
affidavit
day-
may also.
My lord, I may be permitted to complete. One day he comes up with the 1965 rules. The second day, when the 1965 rules have been denied in the affidavit in opposition, he himself relies on rules which were applicable to government schools. And when I seek clarification on those rules and it comes to light that 7 years experience plus B.Ed is required, then he jumps back to the 1965 rules. So, my lord, blowing hot and cold at the same time cannot be a ground to allow the writ petition. And one irregularity committed earlier cannot be the ground to allow the petitioner's prayer for being approved as the assistant headmistress of the school.
Where
And
we
so
said
far as-
65 rules, where we said 65 rules are not applicable any longer? Where we said that?
My lord, that was nowhere the case in the writ petition also. The
No,
affidavit
no,
in
where
opposition-
have you said that in the affidavit? Where you say he's jumped now and
That
said
is,
that?
that is what I'm saying, Lordship. I'm submitting, my lord, that particular point was nowhere taken in the writ petition. So, on the basis of the facts which were there in the writ petition, we have given a complete stand in our
See,
affidavit. in
whatever
opposition.
terms of employment have we governed some rules. And so deficit schools, if the deficit schools, terms of engagement are governed by these Assam Education Rules and Orders 1965. So then if we're still following them, then sum and substance we have to follow them.
If your lordship kindly peruses, I had submitted the Meghalaya School Service Rules 2012 before this honorable
Yeah.
court.
Yes.
Now, if we go to the Schedule 2, which is under Rule 4.1,
Yes.
it clearly says that for appointment as assistant headmaster or headmistress,
Where is that?
the lordship, I had placed it before this honorable
Yes,
court.
I don't know. Page?
Not
Schedule
page,
2.
my lord. It was rules page number 12, my lord.
Yes.
Page
Where's
number
assistant
12,
headmaster?
serial number 1.
Yes.
Assistant headmaster or headmistress, the educational qualification and qualifying service.
Oh yes,
It
now
says
these are in
degree-
force.
It is
Yes,
applicable in
lord,
government
these
school.
are in force.
This
The
is applicable
NCT
in
norms
government
have
school.
adopted
Purely
and these
government
rules have been clear.
Let's see. Meghalaya, he is not in the Meghalaya school service. He is not in Meghalaya school service, correct?
The-
Are you in the Meghalaya school service under these rules? No.
At the deficit school, 65 rule is now today applicable and no amendment is still there. And that
Lordship,
2012 rule is
kindly
applicable in
tell you
government school, provincial school.
Lordship,
There is a
kindly
different
tell you
appointment authority also different. Your Lordship can see that in
Lordship,
deficit school
kindly
appointed
see-
by the managing committee, and in the government
Lordship,
school it is by.
kindly
One
see
second,
order
one
dated 22nd March passed by this Honorable Court.
1 second. Yes, yes. These rules don't apply to them
Not apply.
because these are for government
Lordship will
schools.
kindly, for a moment, Lordship will kindly peruse order dated 22nd March 2024 passed by this Honorable Court. 22-3.
20?
22-3. 22nd March.
Yes.
Lordship will see that the petitioner had produced before this Honorable Court the 2010 rules. Meghalaya School Service Rules 2010.
Yes.
And the petitioner was relying on the 2010 rules because in the 2010 rules, the eligibility criteria to be appointed as assistant headmaster was simply written as 7 years of service. And thereafter, I was granted time to seek
Where is
instructions
this
on
rule
the
2010? What rules did you place
because
after it?
that was
No,
also
on that day-
produced before this Honorable Court, Lordship.
I'm getting confused now.
By
What was the
petitioner.
2010
No,
rules?
that rule also, Your Lordship. Yes, I have
2010 rules were placed by the petitioner.
found. That rule also there, but
Where is that? How did we see you won't just see?
that rule also event actually after.
No, according to our knowledge, before perhaps some rules and orders are applicable. Anyway, even the Constitution Management Committee, EAO, everything.
It is also applicable as per my instruction of it is
My
applicable for
lord, in
government school.
2010 rules,
It's
if
also
2010
medical
rules
school
were
education
It's a
service.
government school, of course. It is for
My lord, this particular rules
One
was
second,
relied
one
upon by
Just same like 2012. I think they supersede 2012.
My lord, the
Okay,
schedule
good.
has changed. The schedule has changed.
change.
1 second. See, all rules, orders, notifications corresponding to enforce immediately. If they're same, that means they stand repeal. 2010.
This
No,
stands
yeah,
repealed. 2010 stands repealed, and the petitioner
2008
is
rule
still
also, Your Lordship, for subsequently I have clarified for it is for government school also.
Yes, this are stand repeal now.
Repeal, Your Lordship. It is not.
Then?
Yes.
It is for government school, Your Lordship. On that day, by mistakenly I have told.
Then you
produced.
raise these rules. Why?
No. That day with me.
5 minutes
By
ago,
mistakenly, I have
my-
I was not clear on that day because it is applicable. Because subsequently, I have come to know it is for government school and deficit school is not applicable because appointment authority is different. In this rule, appointment authority is the government and the deficit school is the managing committee. Your Lordship. The 65 rule is still exists. And Your Lordship also know clear that there is no notification, any administrative instruction cannot overrule the rule. The legislature has power to amend the rule, but till date they have not amended. And this rule was and till today the managing committee is appointing as per 65 rule and all.
Yes.
And moreover, Your Lordship, the assistant headmaster is a post of administrative post. That's why it is not required. In headmaster is being required, but assistant headmaster is only to assist the headmaster in the academic school. That's why this.
Okay, we can't direct for appointment, but we'll direct them to consider and review of the application of the takedown.
And I have also realized some judgment that in this regard, that there's acute right cannot be taken away. In the year 1992, we have appointed. At the time, their notification was not there. Subsequent notification also not applicable in my case. This already has accurate right cannot be taken away by this.
Takedown. take down the writ petitioner. Petitioner on being aggrieved with the non-approval of her application to the post assistant headmaster or vice principal?
Assistant headmistress.
To the post assistant headmaster in Resubelpara Girls Higher Secondary School is before this court praying for directions, praying for proper orders.
It's 32 years.
Yes. Praying for orders to approve the resolution submitted by the managing committee of Resubelpara Girls Higher School, and consequently for quashing of the impugned letters whereby the approval is not granted. So, next paragraph. Mr. S. L. Islam, the head counsel for the petitioner, has submitted that the petitioner is the senior most assistant teacher of Resubelpara Girls Higher Secondary School, North Gara Hills, and was appointed as far back as on 1st November 1992. Stop. It is submitted that it's further submitted that the managing committee in its meeting held on 5/2/2023 promoted the petitioner to the post of assistant headmistress, and that since then she has been discharging her duties as such. However, he submits on the when the approval was sought from the respondent number, director's respondent number, respondent number 2, by impugned letters dated 25/5/2023 and 21/7/2023, the same was rejected. Stop. He contends that the rejection is unjustified inasmuch as the ground as set forth in the impugned letter that the petitioner could not be considered as she does not possess a B.Ed degree is not applicable in her case, inasmuch as in the conditions of service and qualification necessary, the school, being a deficit school, is governed by the amended Assam Aided and Higher Secondary Schools Employees Rules 1965, wherein the qualification required is that a candidate shall hold at least 5 years experience in teaching, apart from other conditions. Stop. He, next para. He further asserts that the executive orders issued by the respondent number 2, whereby it has been instructed that in deficit secondary schools, a candidate without B.Ed degree be not recommended, is not binding, in as much as this requirement has not been inserted in the rules. So, it therefore submits the writ petitioner, being duly qualified and as per the prevalent rules, is liable to be granted approval and appointed formally to the post of assistant headmaster. Assistant?
Headmistress.
Headmistress. Next, MS Dr. P. Agarwal, Learned Counsel, on behalf of the respondents, has placed strong reliance on 2 communications, on 2 letters. First, dated 25th January 2007, on the subject of appointment as assistant teachers in deficit schools. Wherein it is given that all vacancies in deficit secondary schools should be filled up by B.Ed degree holders, and in the letter dated 19 July 2023, which has also mandated that candidates without B.Ed degrees were not eligible for appointment to the post of assistant teachers stroke assistant headmaster stroke headmaster in deficit secondary schools. She therefore submits that in view of the embargo created by these executive orders, notwithstanding the fact that the rules do not speak the same, do not speak of the same, the writ petitioner is not entitled to the prayers in the writ petition. Stop. I've heard the counsel for the parties and examine the materials placed on record. It is noted as submitted by the counsel of the petitioner that it's noted that the petitioner has been appointed as far back as in 1992 and has been serving in the said school continuously. And in 2023 was recommended to the post of assistant headmistress. Stop. No doubt, the rules as applicable do not speak of any added qualification academically, apart from only requiring the teacher to have the requiring teacher to have the qualifying years of service. This court cannot ignore the fact also that since 2007, orders have been issued mandating the requirement of a B.Ed degree to occupy such a post. Stop. Top note, what's that? Namaste. Namaste. Stop. Stop. Continuously. By the Assembly Magic Committee. Stop. Requirement. Huh? Of any added requirement. Only requirement apart from the teacher possessing the to have to possess the qualifying. Stop. This goes next. Stop. This court, however, cannot also ignore the fact since such post. Stop. It is also noted that the Assam
Amended Assam.
Where are you reading from? It is also noted that there is no dispute. It's also noted it's not disputed that the Assam aided higher and higher secondary schools employees rules have been applied. This where does it speak of have been applied to schools receiving maintenance grants or for aided schools, and as such, by strict application of the set rules, this is where's that? That is Rule 5. What is?
Lordship, Rule 5. Rule 5.2. amended Assam High School Higher Secondary School Rule 1965.
Yes.
5.2.
Thomo? Grants or known as aided schools, schools. Stop. At Rule 5, small bracket 2 thereof. Provides as follows accordingly. Okay. Rule 5 provides so and so. Stop. Rule 5 so and so. This provides Rule 5(2) is quoted here and below. Stop. This one you have not brought by affidavit, no?
No, Lordship. Your Lordship had directed me to bring it by way of just to produce before the court. But I have just noticed that these notifications are amended in the writ petition, annexed to the writ petition.
They are already annexed to the petition?
Writ petition I have already
Yes,
annexed.
These two?
Lordship, I have annexed.
Yes, Lordship.
Very good.
It is at page
Page
33
33 and 34.
Both of them?
Both of them, Your Lordship.
Yes, Lordship, both.
Yes, Thomo? Yes. No, Rule 5 also is quoted here in below. Stop. As observed earlier, the state respondents have issued circulars or letters on 15 2007 and 19/7/2023 mandating the requirement of B.Ed degree. Though it has not been argued by the counsel for the state as to whether these directions necessarily have to be included in the rules for implementation, or whether in their application can be set to supplement the same in view of the it can be the same. This court at this juncture, without further dwelling in the matter, in view of discussions being held off, directs the respondent number 2 to take an appropriate decision in this regard within a period of
2 weeks.
2 weeks, within a period of 4 weeks. 4 weeks, a copy to orders presented before said respondent. Matters on sensible. We're not deciding, we won't direct, because the thing is that sometimes we'll not say anything, because there are decisions also where when the rules are silent for something, and if it's complemented or supplemented, then then maybe some decisions taken.
Only
Yes. No?
they have power, state power the amendment, they have not really amendment, and that is running.
Last part,
continuing.
Keeping in mind, keeping in mind the fact that the petitioner has been appointed since 1992, yes, and is serving
Only 2
in
years
the post
left.
of Anson headmistress in a purely administrative capacity.
Yes.
Yes,
Obliged.
Obliged, Lordship.
yes. This is your book. You mean you don't know about executing proceedings, execution proceedings? You must be knowing. You can't allow. Let's see your petition. Let's see the order.
Order.
But I just give their copy. Okay, the copy. We have not given permission as yet. Just go to examine.
First, an ex parte order was passed, my lord, decree was passed in August 2015, my lord.
This is from my court.
Yes, my lord. This is in connection with something else, my lord, where, my lord, in a dead bird and a dead person name, my lord, the order was passed. We have challenged that before this honourable court. This honourable court rejected our petition, my lord, and substitution was allowed.
No, it's too long, Mr. D.
Only thing is this, my lord, since my case has been admitted, my lord, by the district council, my lord. Now, my lord, if they throw me out, my lord, where I'll go at this junction, my lord. Second thing, my lord, till 17, my lord, if I can get some protection, my lord, from this honourable court, till 17, my lord, because my matter is pending before the district council, on 17, my lord, I will place my case. And I'm very confident, my lord, that we'll get some order from the district council, my lord, because the honourable court has not passed an order, my lord, because of, my lord, some delay was there, yes.
See, imagine, no, I'm sorry, Mr. Look at the order of this court. Honorable Court, see the last part, the same incident errant cut out by petitioner entire proceedings, commenced 2010. No application setting aside ex parte was ever filed.
My lord, yes, my
Even
lord,
in the, where the page is missing.
my lord, if I can just point out, my lord, if my lord
Yes, page
allow
8.
me.
Even this one is incomplete. Even this given here is
We have,
Come in the other side, Dr.
on the other side, my
Take
lord.
it as come.
Only thing is this, my lord, because, my lord, a layman come to us, my lord. My lord, if we are not in a position,
Sorry, Mr. D.
only, my lord, till 17 only, my lord.
Execution proceedings.
Because, my lord, what will happen, my lord, here? I have two daughters, my lord. And
Doesn't-
one of the daughters...
Why? See, I remember this case very well now. You've read this
Yes, I have read, my lord. They have just come to us, my lord.
Then?
And, my lord, only thing is this, my lord, an ex parte decree, my lord, which
Where's
is in
the old lawyer who prayed for her?
my lord, that, who has
Should
taken...
have come to you earlier.
Oh, my lord, that we have no
Then?
control.
I know.
We have no control, my lord.
Sorry, see, they have to enjoy the fruits of litigation also. Put yourself in the other. Your name's Swapnil.
Yes, Dr.
Your father teaches in Edmonds.
Worship, yes.
Yes. I met him yesterday. He had gone for that NAC thing, yes.
Only thing is this, my lord, I will just humbly pray on a mercy petition, my lord. May kindly treat this as a mercy petition, my lord. Till 17, my lord. I'm not praying anything because today, my lord, they have brought some bouncer and all, my they are forcing us to throw our things
They
out.
brought who?
Bouncer, my lord. Some bouncer,
Bouncer?
there. Yes, my lord. They have taken some bouncer to throw us out, my lord. Only 3 ladies in the house. One is a doctor, my lord, government doctor. She is a government daughter. And recently only they came to know, my lord. Because this lady, my lord, she is, what I can say, my lord.
See, Mr. Day, we cannot, no matter what the circumstances, court cannot stand away with its own orders. This order.
No,
this
my lord, this order
This
is
order of this court is very clear.
only for a decimal point, my lord, that only till 17, my lord, if they can allow me to stay back, my lord.
You see, you cannot eat what about your condemnation?
No, condemnation application and even the miscase is also pending, my lord, for
30
17.
days. Now you see, since 2010 you didn't file a satisfactory ex parte decree also.
My lord,
Sorry.
the petitioner, my lord,
Sorry.
my lord, may
Although
kindly-
I have the utmost compassion and utmost, I
But
understand that if
my lord, I will be formless, my lord, if the order has not been
you
passed.
go
by
and
the
mention it, you go and mention this council on Monday. Should have mentioned today there for taking the
Monday
matter.
is whole day, my lord. Till now, my lord, the certified copy has not been given to us, my lord. Yesterday, the order was supposed to be given to
Should
us.
have gone and today. Should have gone.
No, my
today,
lord,
sir.
we have requested, my lord. They have played hide and seek, my lord. To be very honest, to
They have
say.
not played. They have got a decree since when?
lord,
And it's been fixed in
lady-
execution
a lady-
2018.
A lady, my lord, if I can just humbly submit, my lord. If I can
Sorry,
just
Mr.
humbly,
Day, sorry.
if I can humbly submit, my
We
lord.
can't.
My lord, only
I
thing
mean,
is
we will not-
this
it'll go
lady is
against-
not in peace of mind, my lord. That is why, my lord. Otherwise, she would have definitely, my lord. If the lawyer, my lord, have not done their job, my lord, properly, it can.
Take down mention issued as CRP. It's not registered, no? Register.
My lord is already there, my lord. If the mention memo is allowed, my lord, they will register it, my lord.
You file it in due course. Let it come up on Monday.
My lord, Monday is again whole day, my lord. They will throw us out, my lord. Only, my lord.
Sorry. This matter is. You tried your best.